Hello, everyone. This is attorney Andre McKinney Dorval, AMD here. First off, guys, how are you all doing? I hope you guys are doing well. It's been a couple of days since I posted, but things are really getting busy, guys, especially for the number of individuals who are being arrested and detained by ICE. But, guys, I hope you all are doing well. I missed you guys. I miss publishing. It seems like if you miss an hour off of YouTube, oh my gosh, so much takes place. But in this video, what I want to talk about are the fees that have gone into effect. USCIS introduced, or published, I should say, the Federal Registry on the fees that the big, beautiful bill has incorporated. And I want to discuss what they are, share with you some things you need to know, as well as in the video with discussing how will this all impact moving forward with the introduction of these fees. Now, for us to dive into this discussion, I do want to share my screen. We're going to take a look. Of course, I'm going to do the reading so you guys don't have to. And it is definitely my pleasure to break this down because sometimes a lot of the information on the government website, sometimes it can seem like a lot of mumbo jumbo, breaking things apart. But we're going to take it step by step. Now, this release date from USCIS discussing the updates on the fees based on HR 1, also known as the Big Beautiful Bill, it was a reconciliation bill. This was released on Friday, July 18th. And right up top, it says that USCIS is publishing Federal Registry notice. I will try to drop that in the description box for you guys based on HR 1, the reconciliation bill. Now, important to note, guys, you see where it says here, applicants must submit the new fees with benefit request postmarked on or after July 22nd, 2025. USCIS will reject any form postmarked on or after August 21st, 2025 without the proper fees. Again, applicants must submit the new fees with the benefit request, whatever that application benefit you're applying for, postmarked on or after July 22nd. It must have the new fees, and after the 21st of August, the government is going to reject any applications without the proper fees. Let's scroll down a little bit further. In the second paragraph here, guys, where it says the FRN, which is Federal Registry Notice, explains when the new fees take effect, instructions on their payment, when and if the fees may be waived, and consequences of the failure to pay. DHS must increase the fees each year based on inflation. We're going to talk a little bit about that at the end of the video. The new fees in the Federal Registry notice are a new fee of $100 for aliens who file Form I-589, which is the application for asylum and for withholding of removal. The annual asylum fee, AAF, of $100, which must be paid online for all aliens with a pending Form I-589 for each calendar year their application remains pending. A new fee for aliens who file Form I-765, the employment authorization application for asylum, parolee, and temporary protective status. And here are the list of categories. For the initial EAD, which is the first application for work permit, for the forms, it's $550. For renewal or extension of the EAD applications, it's $275. There is one exception to these fees. If an alien requests an EAD after the government approves a new period of parole or reparole by filing Form I-131, application for travel documents, parole documents, arrival or departure records, the fee will be the lower HR1 fee of $275. Also, a new special immigrant juvenile fee of $250 for any alien who files a Form I-360 as a special immigrant juvenile, and an increase to the maximum cost to register for TPS of an amount from $50 to $500. Let's go a little bit further down. Here, the government also indicates any alien who filed or files a Form I-589 after October 2024 that remains pending with USCIS for 365 days must pay the annual asylum fee, AAF, is one of the 1 year anniversary of his or her filing date. So 1 year from the date that you initially filed it, your anniversary filing date, and each year thereafter that the application remains pending on such day of the calendar year. The first time the AAF is due, aliens who file for asylum do not need to monitor the time their application has been pending if the AAF applies to them. USCIS will issue personal notices to aliens when their annual asylum fee is due, which will include the amount of the fee, when it must be paid, how the fee must be paid, okay? And also the consequences of failing to pay. That one's real important, guys. We want to take note of that. Here it also says USCIS will provide guidance for future years AAF payments and subsequent issuances. So let's break down this first paragraph. Here's what I want you to know. I have a lot of notes here, guys, just to break all that apart. So it's clear that the bill establishes an annual asylum fee, which must be paid each calendar year that an asylum application, whether it's filed with USCIS or with the immigration court or any other agency or court that has jurisdiction over asylum claims. So if anyone is wondering, does this just apply if I'm in immigration court, or does this just apply if I'm before USCIS? It applies anywhere, whether it's USCIS or immigration court or any other agency that has jurisdiction over asylum claims, meaning they can hear asylum claims. Now, the notice spoken about here, it only addresses the collection of fees for asylum applications pending at USCIS for more than 1 year. However, guys, for cases that have been pending with USCIS on or before October 1st, 2024, and remain pending on September 30th, 2025, which is fiscal year 25, the annual asylum fee must be paid. For applications pending for more than a year prior to October 1st, 2024, additional AAF, annual asylum fee, for years that the application was pending prior to fiscal year 2025 are not required. If the case was filed October 1st, 2024, and remains pending for 365 days, the AAF will be due on each anniversary of the case filing, which is what's stated there. And so, guys, these clarification points, Ayla, which I am a member of, did a really good breakdown of adding more information or providing us members, attorney members, with more information. And I want to share it with you guys so that there's clarity. Let's go a little bit further down. This second paragraph here, second to last paragraph here, the bill also changed the validity periods for some EAD categories. For alien parolees, initial employment authorization is valid for a period of no more than 1 year or for the duration of the alien's parole, whichever is shorter, guys. Okay? Also, for aliens with TPS, initial and renewal employment authorization are valid for no more than 1 year or for the duration of the alien's TPS status, whichever is shorter. And I should note, guys, we do know for TPS, under the regulations, DHS secretary can designate for 18 months. But by its terms, even this reading by its terms basically seems, not even seems, it indicates if TPS is designated for 18 months, the employment authorization will only be good for a year or for the duration of the individual's TPS status, and whichever is shorter. That's going to be a significant change for TPS holders with EAD work authorization. This last paragraph, USCIS will add the fees listed in HR 1 to the fees in 8 CFR Part 106. Each fee must be submitted separately. That means that the fees in HR 1 do not supersede or replace those promulgated by USCIS fee rule. Rather, they will be charged in addition to current fees. If the requester is eligible for a fee waiver for the existing fees under 8 CFR 106.3 sub A, he or she may submit Form I-912 request for a fee waiver or a written fee waiver request in addition to the HR1 fee. The new HR1 fees cannot be waived or reduced. So what does that mean? Guys, this section here in plain English means that the new fees that have been issued under HR 1, they are added on top of any existing fees that USCIS already charges. It's an add-on fee, if I can call it that. So if there was a fee USCIS was already charged, this is added onto it. It doesn't replace it or superseded, as the notice here says. Also, with regards to obtaining a fee waiver, no, these new fees, as stated here, they cannot be waived, nor can they be reduced. The new fees are not waivable or can be reduced. But if you were eligible for a fee waiver for the old USCIS fee, you can still apply for a fee waiver using Form I-912 or submitting a written request for those specific older fees. And as stated here, these fees, each fee must be paid separately. And then the last sentence here, guys, this is important, and that is, the Federal Registry notice does not cover all the new fees required by the bill. DHS will announce implementation of fees not covered in this Federal Registry notice in a future action. These forms have been associated fee changes that are not included in this Federal Registry. And that is the Form I-131, application for travel documentation, parole documents, and arrival departure records, and Form I-102, application for replacement or initial non-immigrant arrival departure document. So, guys, the notice that we just read, it doesn't include all of the new fees that are required by the bill. And as stated here, which I've just read to you, DHS is going to announce how they will collect the remaining new fees later. And these fees for things like travel and or replacement, among other things, DHS is going to make those announcements. So I'm going to stop share there, guys. Guys, we can say in a nutshell, that's a lot of money. It's going to be a lot of money for many individuals who may not be able to afford these new fees. I also want to say, guys, there are also new fees in connection with certain immigration forms that you file if you are in immigration court, such as a motion to reopen, cancellation of removal for green card holder, cancellation of removal for non-green card holder. And maybe I'll do a separate video for that because I don't want this video to be way too long. But the other thing that I want to talk about is that a few things you should take note, and that is these fees, what we just read, a tidbit, one of the other aspects of the big, beautiful bill, HR 1, is that there is provision for annual inflation adjustments to most of the fees, which will begin fiscal year 2026. And for those of you who are unfamiliar with fiscal years, for the federal government, their fiscal year or financial year, if I can say that, it's going to begin October 1st, 2025. So that means the fees that we're talking about today are likely going to increase because in the big, beautiful bill, or there's provision for the fees to increase based on the consumer price index. And so basically, if the prices of, goods and services and all of that financial economic stuff is rising, these fees are going to rise as well. And so, what can we say? What are some of the things that we can probably expect? And that is challenges and potential litigation. And there's at least three things that we can expect if lawsuits are filed, and that is individuals being able to make payment to afford these fees. Because if someone cannot afford to pay the fee, it is, if litigation happens, one of the things we can expect that the plaintiffs will raise to the court, and that is that not being able to have access to the system or access to justice because of the addition of these fees. Particularly, guys, what we just read, those fees, are fees, new fees in connection with the humanitarian type filings. Another thing that we can expect is that administrative, burdens and the whole process becoming burdensome on applicants, sponsors, and individuals who are stakeholders as far as if you're applying or defending a particular application in the immigration process. And so that is something that we can expect that it's going to impact individuals, not to mention rejections, right? If after August 21st, 2025, you have not submitted the correct amount of fee or submitted the fee at all that is now required, your filing is going to be rejected. That's going to be quite significant, particularly for individuals who apply for asylum. Asylum does have a 1 year filing deadline. And so all of these things are going to have to stay into account. And again, these fees are definitely we're going to see them, increase over time. Also, and this is probably the larger impact that is a byproduct or will be a byproduct of these increase in fees, and that is it's going to have a chilling effect or a application deterrent effect, and that is the increased cost for many is going to serve as a deterrent not to apply, particularly for those who do not have the financial or means to pay for example, an initial EAD in connection with the asylum application, where that's huge. And so what we're seeing is that really these fees are really more and more, it's going to be the burden of the applicant or sponsor to be able to finance and fund their application process, not just once you file your application, but also during the time period that your application is pending. And if I didn't say it already, these fees and the changes, I believe I did read it in the notice, they go into effect immediately. And so, guys, I wanted to share this with you because you guys need to know if you are someone who's applied for asylum and you have a pending asylum application, you want to be sure that you work with your attorney or connect with an attorney to ensure that you are clear on what your financial obligations are with regards to the fees, which are in effect now, guys. Also, I want to state that this bears so much importance to say, make sure your address on file, guys, with immigration is correct. Because if you are one of the ones that receives notice with the address that you have provided to USCIS that they're using, but you have since moved and you haven't updated your address, you definitely want to make sure that USCIS has your correct address on file. In the event you do receive notification from the government concerning any fees in connection with an immigration application benefit or application filed with the immigration court, that's going to be important, guys, because you don't want any benefit denied or dismissed because you haven't paid the required fee under the big, beautiful bill. Guys, this was updated information. Again, I will leave the links to the particular USCIS informational press release that we just read, as well as, excuse me, the Federal Registry. Once more, guys, I do thank all of you for watching. Please be sure to like, share, and subscribe, guys. I will definitely see you guys in the next one. Be well, be safe. Bye-bye.